Hello and welcome to the Minimum Competence episode for Friday, March 28th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we cover Senate Republicans gutting overdraft fee caps, Trump targeting WilmerHale, attacks on DEI grants, and a judge's order to preserve Yemen war chat logs. Let's remember, Signal might be secure, but not if you invite randos to your group chat and read today's legal news. On this day in legal history, March 28, 1898, the U.S. Supreme Court issued a landmark decision in United States v. Wong Kim Ark, affirming that a child born in the United States to Chinese immigrant parents was a U.S. citizen by virtue of the 14th Amendment. Wong Kim Ark was born in San Francisco in 1873 to Chinese nationals who were legally residing in the U.S., but ineligible for naturalization due to prevailing immigration laws. After a visit to China in 1895, he was denied re-entry on the grounds of the Chinese Exclusion Act, which severely restricted immigration from China and barred Chinese nationals from becoming citizens. The court rejected the government's argument that children of Chinese immigrants were not subject to U.S. jurisdiction and thus not entitled to birthright citizenship. In a 6-2 decision, the court held that the 14th Amendment guaranteed citizenship to nearly all individuals born on U.S. soil, regardless of their nationality or immigration status of their parents. This decision established a major precedent for interpreting the Citizenship Clause of the 14th Amendment and reinforced the principle of jus soli, or right of the soil. The ruling came during a period of intense anti-Chinese sentiment when the Chinese Exclusion Act of 1882 and its extensions aimed to restrict Chinese immigration and civil rights. Wong Kim Ark was a significant rebuke to efforts that sought to limit the constitutional rights of U.S.-born children of immigrants, and it laid the foundation for future interpretations of birthright citizenship. The Senate's vote to repeal the Consumer Financial Protection Bureau's $5 cap on overdraft fees is a clear signal. Protecting bank profits matters more to Senate Republicans than shielding consumers from predatory financial practices. With a 52-48 vote, Republicans, joined by only one Democrat, moved to dismantle a regulation designed to curb exploitative overdraft charges that routinely hit working-class Americans the hardest. This isn't a technical policy disagreement, it's a choice to side with an industry that routinely charges Americans up to $35 for covering small shortfalls, even when the overdrafted amount is often less than the fee itself. The CFPB's rule was narrow, targeting only large banks and credit unions with more than $10 billion in assets, and still allowed higher fees if justified by actual costs. It was a modest, evidence-based consumer protection measure. The financial industry's immediate lawsuit and the GOP's use of the Congressional Review Act to kill the rule reveal the coordinated effort to preserve a lucrative revenue stream. The overdraft fee fight is just one piece of broader Republican strategy to roll back protections the CFPB has implemented, protections meant to hold powerful financial institutions accountable. No one should mistake this vote as anything other than what it is, an effort by Senate Republicans to keep consumers on the hook, ensuring that banks and credit unions can continue bleeding them dry in the name of choice or flexibility or whatever else. Buzzwords that conveniently mask an enduring deference to corporate power. They'll couch these kinds of moves in language of fairness, pretending they ensure lower-income consumers are given access to these financial instruments. A moment's reflection, however, makes it clear that even under the best-addressed reasoning, they're looking to enable banks to charge exorbitant fees to account holders that are in precarity. Yesterday, President Donald Trump issued an executive order against the prominent law firm WilmerHale following its connections to Robert Mueller, the former special counsel who led the investigation into Russian interference in the 2016 election. The order directs federal agencies to cancel contracts with WilmerHale's clients, revoke lawyers' security clearances, and restrict access to U.S. government buildings. This is part of a broader strategy targeting law firms with ties to Mueller's investigation, including Perkins Coie, Paul Weiss, and Jenner and Block. Trump criticized Mueller's investigation as an example of government overreach, labeling it as politically motivated. In addition to its ties to Mueller, Trump also accused WilmerHale of discriminatory practices in its diversity programs, echoing similar claims against other law firms earlier this month. The firm, which has long-standing history of handling high-profile cases, responded by labeling the order unlawful and vowed to seek appropriate remedies. WilmerHale, a major player in litigation with over 1,100 lawyers, represents a variety of high-profile clients, including Gilead, Comcast, and Meta Platforms. The firm has also been involved in cases challenging actions taken by the Trump administration, fueling further tensions. Notably, Trump also targeted other firms for their involvement in the Russia investigation and opposition research, but some, like Paul Weiss, have managed to have orders rescinded by agreeing to specific terms, including providing legal services aligned with Trump's agenda. The delicious flavor of boot. A federal judge has temporarily blocked the Trump administration from enforcing a Labor Department rule that would force grant recipients to abandon their diversity, equity, and inclusion programs. The decision, issued by U.S. District Judge Matthew Kennelly in Chicago, halts a 2-week enforcement window of a January executive order that required organizations receiving federal funds to certify they don't operate any DEI initiatives, even those unrelated to their grants. The case was brought by Chicago Women in Trades, or CWIT, a nonprofit that trains women for skilled labor jobs and receives federal funding. The judge sided with CWIT's argument that the DEI restriction violates First Amendment protections, noting that such a rule could pressure grantees into self-censorship. Kennelly also blocked the Labor Department from terminating CWIT's funding under Trump's directive to eliminate equity-related grants, though this protection applies only to CWIT and not nationwide. Kennelly's order represents a legal pushback against Trump's broader effort to dismantle DEI initiatives across government agencies and contractors. While a federal appeals court recently upheld a temporary ban on DEI programs in federal agencies and contracting businesses, this ruling suggests courts may scrutinize how far the administration can go in policing DEI-related activity outside direct federal oversight. The ruling underscores an emerging legal battleground over free speech, anti-discrimination law, and the limits of executive authority in regulating DEI efforts. A federal judge has ordered the Trump administration to preserve signal messages exchanged by top officials regarding planned military strikes in Yemen. The messages, inadvertently shared with a journalist from The Atlantic, revealed internal discussions involving Defense Secretary Pete Hegseth and CEI Director John Ratcliffe about timing and targets of attacks against the Houthi militant group. U.S. District Judge James Boasberg's ruling mandates that all signal messages sent between March 11th and March 15th be retained by the agencies involved. The order came in response to a lawsuit filed by American Oversight, a government watchdog group, which argued that the use of auto-deleting messaging apps like Signal violated federal record-keeping laws. The lawsuit doesn't focus on the national security aspects of the disclosure, but rather on the legal obligation of government agencies to preserve official communications. The controversy deepened after Attorney General Pam Bondi publicly criticized Boasberg, accusing him of political bias and claiming he was attempting to obstruct Trump's agenda. Trump himself has previously called for Boasberg's impeachment after the judge blocked a deportation policy targeting Venezuelan migrants, an action later upheld by an appeals court. The White House has not commented on the matter, but the episode has sparked scrutiny over the administration's handling of sensitive military planning and whether efforts to bypass official communication channels undermine transparency and accountability. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday. And until then, note, we like to close out the week of shows with a featured musical piece. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing theme ends here. This week's closing theme is by Sergei Rachmaninoff. This week's closing theme is one of the most beloved and instantly recognizable moments in all of classical music. Variation 18 from Rhapsody on a Theme of Paganini, Opus 43 by Sergei Rachmaninoff, in a solo piano arrangement by Schultz. Rachmaninoff composed the Rhapsody in 1934 during his later years in exile from Russia, blending his romantic sensibilities with virtuoso brilliance. The work is a set of 24 variations on the 24th Caprice by Niccolò Paganini, itself a legendary theme known for dazzling technical demands. While most of the piece is fiery and rhythmic, the 18th variation stands apart, lyrical, sweeping, and emotionally expansive. In fact, it's a musical inversion of Paganini's theme, reimagined as a lush romantic melody that seems to rise straight out of the piano's depths. Rachmaninoff himself admitted it was his favorite part of the piece, and it's easy to understand why. It's tender, grand, and full of longing. This solo arrangement by Schultz pares down the orchestral drama, but keeps all the same expressive power, letting the piano sing with full-hearted warmth. The variation has since transcended its classical origins, appearing in films, commercials, and pop culture, yet it never loses its emotional punch. It's the kind of music that doesn't need explanation, it just resonates. Rachmaninoff, ever the late romantic in a century veering toward modernism, poured his soul into his music. This variation, placed deep in a virtuosic whirlwind, emerges like a moment of clarity, an unguarded confession in a storm. Let it carry you out this week. Without further ado, Rhapsody on a Theme of Paganini, Opus 43 by Sergei Rachmaninoff. Enjoy.